welcome back everybody. Our final presentation for Convey 22 is the real hot topic, preparing for and surviving inspections under OSHA's new Heat Illness National Emphasis Program. Our next speaker is Aaron Gelb. He's the OSHA Employment and Defense Partner at Conn Mayshill Carey. During his 25 years as an OSHA employment lawyer, he advises and represents clients in relation to inspections, investigations, and enforcement actions involving federal OSHA and state plan agencies. He also manages the full range of litigation against OSHA, including appeals of citations, negotiations of settlements, geared to minimize the impact of enforcement actions on wrongful death and personal injury civil cases, and trials before the OSHA Occupational Safety and Health Review Commission. So one thing I just want to do a little plug here before Aaron gets started, NGFA Harvest Safety Week, August 22nd through the 26th. And obviously our Harvest Safety Week, that topic is going to be heat, injury, and illness. And Aaron is going to be doing a webinar on that very topic as well. And we are currently working on getting a representative from OSHA to also do a presentation. So that's going to be the theme for the Harvest Safety Week. There's going to be more information coming out, so you can go to the NGFA webpage, but we'll have more information on that coming out. But if you want to mark that down, it's August 22nd through the 26th for Harvest Safety Week. So with that, I'll turn it over to Aaron for his presentation.
Thanks, Jess. Nice to see everybody. So I'm going to come down here if that's all right. I know we're kind of spread out, so I'll walk around a little bit. In getting ready for this, we were talking about COVID, and if I start coughing, I recovered about 3 weeks ago, so I apologize. And one of the things we were talking about with COVID was over the past 2+ years, really that's been the overwhelming focus at OSHA. Right, most of the rules, the healthcare rule, the vaccinator test rule, most of the inspections, certainly most of the complaints, right? I mean, I know area offices in Illinois where I'm based, they come in on Monday morning that have 50, 75 complaints, all COVID related. So that was most of their focus. And now I'd like to think or hope that we're coming out from this, right? We're back to normal, we're meeting in person again, we're not wearing masks everywhere we go. What I've seen on the ground from OSHA with the inspections that I've been managing is that they are back looking at traditional safety and health issues. And they are really focusing, looking to get back out there to do as many inspections that are not COVID related. And so I think the Heat Illness National Emphasis Program, which is what we're going to be talking about today, is an indicator of that focus, right? That they are going to get out there, they're going to be in the field, and they are looking for reasons to inspect workplaces for hazards other than COVID. So what we're going to talk about today, just to kind of give it a quick overview, I want to talk a little bit about how OSHA has historically handled and addressed heat hazards in the workplace. We'll take a quick look at some of the state plan states, right? If those of you that are familiar, hopefully the difference, you got FedOSHA that oversees safety and health in a majority of the states, and then you have a number of states where it's a state plan state, so California, Oregon, Washington, but then also states like Iowa, Indiana, Minnesota, Michigan, where the state runs safety and health issues. So we'll talk about those states that have already adopted heat illness rules. Then we'll get into the NEP. And so one of the things that OSHA lawyers are really, I think, guilty of is that we use a lot of acronyms and abbreviations. So the NEP that we're talking about is the National Emphasis Program. And the reason why I think emphasis programs are important and everyone should really be mindful of what are the emphasis programs that apply to your industry is because those are the inspections or those are the programs that get OSHA into your facilities even when you haven't had an incident, right? So we all know you have a fatality or a hospitalization or an amputation, you have an obligation to call OSHA, right, in certain circumstances. Definitely talk to your consultant, to your lawyer to make sure it is a reportable incident. But when you report it, OSHA shows up, right? If your employees make a complaint, there's a good chance that OSHA is going to show up, or at least a fair chance. And so we all know that. These emphasis programs mean that you get selected based on your membership or your NAICS code, the type of industry you're in, The area office works with the national office, they develop inspection lists, and they just go down that list one by one, and they show up at those facilities. You could have a perfect injury, you could have a 300 log with nothing on it. You haven't had a single recordable in a year, you haven't had a complaint, nobody's been hurt, and OSHA can still show up, and when they have these programmed inspections, they can look at all aspects covered by that program, right? So there's a amputations emphasis program, so they come out and look at your lockout tagout program. I'm sure many of you know that there are, in certain regions, there are grain emphasis or grain handling emphasis programs in Region 5, where I'm based. A number of my clients have been inspected under the local emphasis program on grain handling. And what sometimes happens is they show up for the emphasis program inspection and then they find out something else. So we had one situation where the emphasis program inspection was going well, everything seemed fine, and then apparently in one of those private employee interviews, somebody mentioned that there had been an engulfment. Well, then they opened a separate inspection, and that didn't turn out so well for the employer. So the emphasis programs get them into your workplace. And so that's why now that OSHA has announced and just started this HEAT National Emphasis Program, we wanted to bring it to everybody's attention, make sure you knew what OSHA is going to be looking at, why they're doing this, and then particularly if they show up, what questions are they going to be asking, what documents are they going to be looking for, and then how are they going to be looking to potentially use that emphasis inspection either to expand into a more focused inspection on heat, or if they show up for some other reason, say somebody complains about your bin entry program, they don't feel safe when they're entering a bin, how they're going to take that and turn it into a heat emphasis inspection. So just to set the stage, heat is the leading reason for fatalities in the weather-related reason within the workplace. So that alone, that's when you ask why is OSHA adopting this emphasis NEP for heat, that's why. I think we can get out of the way there. Excessive heat obviously can cause heat stroke or death. So it has the potential, certainly for folks that work outdoors, that are performing heavy labor, strenuous work, has the potential to have a serious impact. As I mentioned a minute ago, there are 4 states right now that have heat or weather-related rules that I think is certainly going to expand. OSHA has begun a rulemaking process that our firm is working on to submit comments and feedback to the agency. So we expect, I think we were talking maybe in 2 years from now, it's a good chance that there'll be a rule. And that's significant, right? Because up until now, OSHA has only been able to enforce and issue citations under the general duty clause. And that is a higher bar for the agency because they have to establish hazard recognition, they have to establish that you don't have feasible means of abatement or corrective measures in place. And if you have effective measures in place and they can't find other things that you should be doing, it's very difficult for them to issue a citation under the general duty clause. With a rule, right, if you're familiar with, think about certain rules like lockout, tagout, or respiratory protection, there are a host of different sections, right? So even if you're doing 90% of the things correct under that standard, if you don't have documentation, if you don't have training, if you don't have certain parts of your program, they can just cite you for that one thing. So once there's a heat illness rule in place, it's going to be much easier for the agency to cite than they currently can under the general duty clause. So how has OSHA addressed heat hazards in the past? There has been a campaign focused on heat illness, but that is different than an emphasis program. A campaign is simply, as you can see, basically they have a web page, they have certain safety and health topics that they cover, they make a focus in certain presentations and outreach. They have a mobile app, which I just checked this morning. If you don't have it, it is a good app. It's got, when you open the app up, it'll tell you what the effective temperature is. And I was looking today, it's still safe right now. It's safe, it will be safe according to the app until noon. Right now it's just a warning phase because we're under 80 degrees. But according to the app, once from noon till 10 o'clock tonight, it then goes into the warning stage. And so that is something that your personnel can use, to at least kind of orient them to, encourage them to check the app. It's geolocated, so it tells them where they are and what the temperature is going to be. And then there are even controls. You can click a button and it'll take you to the different things that you should be doing based on the weather. But that's really kind of been the sum total of what OSHA was doing prior to this NEP. Let's talk a little bit about what does OSHA view as risky. When you look at these numbers, it's actually, I think it was a little surprising to me. You think of hot weather, right? And I certainly don't think of anything in the 70 to 77 degree range to be particularly risky. I live in Chicago. For us, I think the bigger hazard seems to be cold weather. But the way OSHA uses this chart and it kind of interprets the weather is, so on the left-hand column, WBGT, which is wet bulb globe temperature, and that is a combination of the heat and the humidity. And so the way you look at this is first you need to determine the effective temperature, which is a combination of the type of work that is being done. So that's your first question, is what kind of work are we doing, right? Is this, if somebody who is perhaps, especially with COVID, maybe you had some clients in the industry that moved their scale attendant outside in a tent, so this person is in the shade, they're just standing there manning a scale. That's light work. But folks that are doing heavy work, they're shoveling, they're carrying things. So what type of work? What is the temperature? What is the humidity? Take the measurements. And then what type of clothing or PPE are they wearing? If they're wearing heavy clothing or some sort of PPE that limits their ability to perspire or keeps the heat on their body, those factors taken together determine the effective temperature. And then you need to look at whether the person is acclimatized or not. So acclimatized is kind of a fancy word. My grandmother grew up on a farm in North Dakota. She used to say accustomed. It took us a long time to get accustomed to the heat. That's what acclimatization is. And if you think about those first few warm days in the spring, right? It's been cold, and then suddenly, when I was we were in Chicago this spring, we went from like 70 degrees to 100 for a couple of days. So someone who's been working outside in 65, 70 degrees, and then suddenly it's 100, they're not accustomed to that heat. So if you have somebody, if you look on the chart here, someone who is even in 70, 75 degrees, if they are unacclimatized or unaccustomed to the heat and they're doing strenuous work, that may be unsafe even at that level. Then obviously when you get down to, once it's over 77 degrees, over 80 degrees, whether it's even for acclimatized or people who are accustomed to heat, there is a potential hazard. So how has OSHA historically handled citations or issued citations when doing inspections relating to heat? As you can see, I'm not standing here going to sounding the alarm or saying historically that this has been a big issue for employers. So you look at kind of each of the last 4 years, anywhere from really in 2020, no surprise, again, focus was COVID, basically 1 citation per month for heat on average. It's gone as high as 31 in 2019. So this isn't an area that is frequently cited, but again, the reason we're talking about this with this emphasis program is that we expect these numbers to rise significantly. And you could see the more common response or outcome of an inspection was a hazard alert letter, or HAL. And so that's the lighter blue bars there. And so those are issued when OSHA determines we don't really have enough to issue a citation under the general duty clause, but we're going to send this hazard alert letter to you. And what's the intent or the purpose behind that, right? It's putting you on notice. So if you have a hazard alert letter, you're now aware of the hazard, and if something happens, right, it's raising the stakes. And it then creates or gives the agency the ability to establish that you have knowledge of this hazard, and it makes it all the more important to act. So just to briefly recap, there were 2 cases that I think are instructive as far as what's happened when employers were cited under the general duty clause for heat illness hazards. In one involving the Postal Service, they received, after an employee died, the Postal Service was given a willful citation and a $70,000 fine, which back in 2014 was the maximum fine that could be levied under the OSHA Act. I think, as everyone probably knows now, that penalty structure changed around 2016, and for a willful or repeat citation, the fine can go as high as around $145,000, so that the stakes are even higher. And particularly significant, a willful citation issued when there's a fatality can lead to criminal prosecution, right? So you certainly don't want that, right? You certainly don't want, obviously, one of the main reason that we're here when talking about safety is to prevent illnesses, to prevent fatalities. But I find that sometimes when the decision makers are a little reluctant to do something, if you emphasize, look, if we don't get this taken care of, if we don't address this issue, not only is there the potential for a significant fine, but there's the potential for to be indicted, the matter can be referred to a grand jury, and then possibly prosecuted. And so in the Postal Service case, the other case, the Sturgill roofing case, in that instance, the employer, both cases, the employers contested or appealed the citations. Postal Service lost, and the roofing company won. And I think there are a couple of basic reasons. One, the facts were really bad in the Postal Service case. As a lawyer, I would often say, bad facts make bad law. And so in that case, it was, I think, over 90 degrees several days in a row. There was a mail carrier. He was scheduled to work a regular shift plus about an hour and a half of overtime. His first day, the first day of the heat wave, he calls his boss, "I don't feel well. I need to stop working." "No, get back on your route, finish your overtime." He does it. Next day, he tries to call off, same thing. "Nope, get out there, finish your work, finish your overtime." Collapses on his route, and he dies. In addition to that, the Postal Service, which kind of surprised me, didn't really have a good heat illness program. Obviously, I think part of the reason why that supervisor probably did what he did was that he didn't have the program behind him, the training, the knowledge to know what to do in a situation like that. And so when they contested it, they litigated it, they lost, as I would have expected they would have given those facts. Sturgill Roofing was a very different case. It was the employer, as I would hope for a roofing company, does a lot of commercial roofing. They had a very solid written program. They had extensive training. They covered heat illness in pre-shift meetings. They trained their supervisors additional to what the employees received. And the person who passed away in that case was a temporary worker, right, which is another area of risk, right? People who are assigned to your workplace, their first day, you don't know them. You don't know their background. You haven't had a chance to talk to them, perhaps. A longer-term employee, you might know that, Sam has had heart surgery, or, Fred had a serious illness. They didn't know that this gentleman had apparently been diagnosed with congestive heart failure in the past. He had hepatitis C. And so they assigned him to the lightest possible work. They instructed him to take breaks. They instructed him to drink water. They had ample water available. And nonetheless, he was observed acting strange. Somebody reported it, which shows, I think, that effective training. Paramedics were summoned, and he passed out, and unfortunately, he passed away a few weeks later. And in that case, they also appealed, but they won. And the commission held that given their program, given their training, and given the actual facts on the ground, that was not a citable offense. So I think those are probably extremes. I think a lot of the cases fall somewhere in between. But to me, it really just illustrates the importance of having a program and doing training so people know what the program requires. So just quickly, I want to run through a couple of the state plan programs and what they cover. I think it's interesting when you look at each one they're all slightly different. right? Some of them require a written program, some of them don't. Some of them address shade and water, some of them don't. Now, Minnesota is kind of an outlier. I think it's more, Minnesota's rule, for those of you, if anyone has operations in Minnesota, there's also a minimum temperature rule in Minnesota for indoor work, which one of my trucking clients found out the hard way when they got cited because it was under 65 degrees in a warehouse in Minnesota in February. Trying to have a discussion with Minnesota OSHA about how it's really not possible to keep a warehouse, with 80 bay doors for a trucking operation warm is another story. But Minnesota is kind of the outlier. But if you look at Oregon and Washington's rules are newer. You tend to see that there are requirements for high heat days that are added on in addition to the regular requirements. Typically, there are requirements to have additional breaks, to have water available, certain amounts of water in 3 of the 4 situations. Having California, Oregon, and Washington all require emergency response plans. So if you look at these plans, and the reason I'm talking about this is California, which is, I think, certainly was the first state to come out with a heat illness rule. Doug Parker, who was the head of Cal OSHA, who oversaw California's development of their heat outdoor rule, they had also introduced an indoor rule, which is still working its way through the development process. But Doug Parker is now the Assistant Secretary of Labor for OSHA. So when we want to try to get a sense of what OSHA is likely to do, we look at what Doug did in California. And so I think it's particularly important to note that the heat rule in California is the second most frequently cited standard in California. I think number 1 is probably their illness and injury prevention program requirement. So I think there's a good chance that if you look at California's rule, that's a good model for what we're going to see in the rulemaking process at Fed OSHA. So what are the key components of the California rule? It's to have a written program, like I keep talking about. It's to train employees. It's to make sure that you supply a certain amount of water. In California, it's up at least 1 quart per hour. Generally, the rules are that water needs to be cool, which is typically defined as cooler than the ambient or outside temperature, but apparently not so cold that it's painful or uncomfortable to drink. And then, as I said, the California rule requires providing access to shade, encouraging employees to take breaks and to drink water. In one of the heat-focused inspections that I recently managed for a client, I did find that OSHA was particularly impressed that this client tracked the weather and implemented additional breaks when the weather reached a certain point. And their managers all knew that. The employees all knew that when they were interviewed. And that gets to that, I think, why the training is so important, because typically, when OSHA goes out and does the inspection, they're talking to your employees. Hopefully your supervisors know these things, but if your employees are able to communicate to OSHA that this is what my employer does when it's hot, this is what I know I can take additional breaks, I know I'm encouraged to drink water, that goes a long way, right? The inspections, when the compliance officer is talking to an employee and asks them, are you a lockout authorized employee? And the person just looks at the inspector blankly, like has no idea what they're talking about, that's going to change the compliance officer's perception of the company. And often that's that decision point where they're like, am I going to dig into this deeper or am I going to end my inspection? So if your employees know what the program provides for and what they should be doing, I think that greatly increases the likelihood of a positive outcome in your inspection. All right, so let's talk about the NEP. It took effect about 3+ months ago in April. It's gonna be in effect for 3 years. It applies to both. I know much of what in this industry is outdoor work, but it also applies to your indoor work settings. So if somebody is working in an enclosed area and there's heat in there, even though they have shade, right, it can still be hazardous depending on the work, depending on the temperature. In addition, right now, I think historically OSHA, only about 0.5% of inspections were heat-focused inspections, so not a great number or not a particularly large number. The NEP sets a requirement for each region to double the number of heat inspections from 0.5% to up to 1%. So, I certainly, we looked at that chart before that showed the number of citations. I think that's going to significantly increase for some reasons I'll get into in a second, but certainly more inspections are going to equal more citations. And again, I don't want to remain just focused kind of tunnel vision on heat. More inspections also just mean more citations generally, right? The statistics show that when OSHA does an inspection, 75% of the time or so, they issue at least one citation. So even if they come out and they find that your heat program is good, if they walk by an unguarded conveyor or they are talking to somebody about your bin entry program and they say something, right? There are lots of other things that they can learn when they're inspecting the heat program, or things that they may see, obviously. So priority is going to be given to fatality. Yes?
So, quick question. As I understand in the appendix to the NEP, they have the NACS code for the grain feed and processing
Yes.
industry, correct?
Yep.
So that means the industry is part of the, I guess you could say it's part of the target list. Is that correct? And you're going to cover, okay.
Yep,
All right.
I'll jump ahead to this.
Okay.
Yeah, so if you look at the top there, so there are 70 or so high-risk injuries or industries where heat is determined to be a particular hazard. And those are the industries where, when I talked at the outset, that OSHA will be going out and proactively inspecting even when there is no issue or no complaint or no reported incident. And so it applies both to 1151 as well as I think it's 4245. So if those are your NAICS codes, if you don't know what your NAICS code is, you can look it up. It's, I think, through actually the census website, interestingly enough. But know your NAICS code and then know whether or not you're on the high-risk industry list. All right. So OSHA will be prioritizing, obviously, I mean, they do anyway, but heat-related fatalities, hospitalizations that are reported. And these are called, as I said earlier, there's this is a programmed inspection, right? Unprogrammed activities are reported incidents, but also complaints. And I think probably the biggest difference that we're going to see is the in-person inspection of complaints. Most of my clients, when they get, I'm sure many of you have gotten, right? You get that letter in the mail, or maybe you get a call from OSHA, and then they say, we're sending you a letter. And then you get that, it's got that little inset where it's like, alleged hazard is, it could be heat, it could be whatever it is. And they just said, you've got 5 business days, send us a letter back, post a copy of this complaint and send us your response. You tell them that there's no hazard, you tell them what you're doing to make sure that there is no hazard going forward. And then either that day or a couple days later, you get a call or a letter, we're closing this matter, everything's satisfactory. I think when OSHA gets complaints about heat, they're gonna come out. I think they are going to prioritize those complaints and do in-person inspections instead of the kind of the phone and fax inspection that we talk about. We're also, I think, going to see a lot of follow-up inspections. So if you've had a heat illness inspection in the past, or you've been cited under the general duty clause, or even if you got one of those hazard alert letters, I think there's a good chance that you're going to get a monitoring inspection. That's been one area. Another area on the ground that I've seen a lot recently, a number of my clients that have been cited in the past have OSHA showing up, even for citations that were issued 2, 3, 4 years ago. Lockout, tagout. I had one in a slip and fall case where they came out to a hospital and they wanted to see the location of the slip and fall, which was a hallway, and that was their monitoring inspection. So, and then the last piece is that it's not required that the state plans adopt this emphasis program, but they're encouraged to do so. And they should have, as about a month ago, they should have notified OSHA whether or not they intend to do so. So if you are in a state plan state, that you can look that up or reach out and we can try to find that out for you. I think I've kind of covered this, but again, what are the different types of inspections that OSHA is going to be doing under the NEP? The unprogrammed inspections for fatalities, for complaints. Interestingly enough, they're also focusing on referrals from other agencies. So if, and particularly wage and hour, because I think they view this industry as one where there are higher than normal number of wage and hour violations. So if the wage and hour division is out doing an inspection, they may notify OSHA, and then OSHA is going to come out because your site has gotten a complaint about wage and hour. We saw, Jess, I don't know if you saw this, but kind of unprecedented. OSHA just opened up a series of inspections that were referred from the U.S. Attorney's Office of Amazon, and kind of did this mass, I think, coordinated set of inspections at various Amazon facilities across the country because of allegations that are being investigated criminally by the U.S. Attorney's Office. So you're seeing, I think, I don't know if it's unprecedented, but definitely a new level of coordination amongst government agencies. So if you are dealing with an agency, even I wouldn't be surprised, like EEOC or NLRB, if they are getting complaints from your employees about heat, that may prompt an OSHA inspection. I mentioned the monitoring inspections and, of course, the programmed inspections. So just quickly, the statistics so far, at least through June 21st, again, the NEP went into effect on April 8th. There were only 12 inspections that were conducted in response to a reported fatality or hospitalization. As I said, the facts kind of bear out what I expected, which is majority of the in-person inspections were resulting from complaints, 110. We don't have the stats yet on how many of these were just these kind of programmed or list-based inspections. A significant number, not surprisingly, in construction, and then the remaining inspections, 151, were in general industry, which is what you all would likely fall under, at least according to the statistics we've seen. All right, we covered that one. So I mentioned that app, right? When tracking the temperature, it kind of tells you, based on how hot it is, what level of protections are needed. So on heat priority days, which is anything over 80, and I looked at the weather here in Omaha, I don't think it's going to be below 80 anytime soon, not likely in Chicago either. Much large parts of the country are going to be over 80 for quite some time. And so in addition to compliance assistance, which is not something you need to concern yourself, right? That's OSHA kind of doing outreach and advising employers and being helpful, hopefully. But what it really means is when it's over 80, if they come out for another reason, again, any other type of safety issue, other type of complaint, they will ask your employees about heat. They're going to ask you questions about heat. It's kind of like when I'm dealing with a traditional safety inspection in a factory and a forklift drives by in Chicago. They have a local emphasis program on pit safety. They every time I've done this, I've been doing one of these inspections, the compliance officer stops the driver, they take them aside, they ask them about the pit program, they ask them about their training, they ask them about their pre-shift inspections. So they are doing this. In other words, like when they're out for one reason, they know when they go out that day, their boss is probably going to tell them, remember, this is a heat emphasis day, so make sure if you're out for this, that you're asking about the heat program, you're asking these questions of the employees you talk to. I think this is really one of I mentioned this earlier about expanding inspections. I think this is an important point, again, to remember. So when they're out there for these other reasons at your work site, if they observe hazardous conditions, right? They see people working outside without any shade. Maybe they see there's no water available. If an employee, in the course of their talking to that employee about this other issue, they're going to ask them some questions, so the employee brings some concerns to the compliance officer's attention. Those are all things that they're going to use to expand the inspection. They're also going to look at your 300 logs. And if they see, so if they're out inspecting, a bin entry complaint, and they look at your log and they see that somebody was hospitalized due to heat stroke, that will, I think, pretty much automatically result in a separate inspection being opened into your heat program. So again, they are looking for reasons to expand and look at your heat programs. so let's say now you're selected under the emphasis program for an inspection. What's going to happen? As I said, they're going to come and look at your 300 logs, your 301 incident reports, look for any evidence of heat-related hazards. If you have other documentation, right, if there is an incident, they're going to ask for all the documents relating to that incident, to possibly to emails, to memos, to the medical records that you may have gotten. They've even set up a program where they have a procedure in place to request and obtain copies of medical records under what's called the medical access order. So they've thought about this a lot. And then they're specifically going to be interviewing people, asking them, even if people who don't know that they've had heat illness, they're going to ask them questions about symptoms, about different indicators of heat illness, and maybe determine that someone is experiencing it or has experienced it and didn't know it. And then, I think last but not least, the compliance officers are tasked with determining whether you have a program, whether it's a written program, and how effectively or thoroughly you've implemented that program. And so when they're doing that, right, obviously the easiest way to answer that question is to provide a copy of your program. And I always, and it applies to many circumstances, I always talk about Mike Tyson's comment, right? Like, everybody has a plan until they get punched in the mouth. And the point of having a program is that you know what to do when something happens. And I think that's one of the biggest, where I see time and time again, where employers fall short and have problems. The managers, the supervisors, superintendents don't know what to do when somebody is not feeling well, when somebody is hurt, right? And that little window of time perhaps, could have resulted in a different outcome if the person knew what to do. And having that program that has the various elements, particularly, again, the training, can really make a big difference. And I see in the room several friends who are in the consulting industry. I would highly encourage you, I don't draft them myself, hire a consultant, hire a safety expert who can work with you, who knows your business, and can develop a heat illness program for you. And help you customize it. I know a lot of people want to save money and download something from the internet. That's better than nothing, but I do think a customized program is the ideal thing to have in place, and then work with that safety expert to really help put it in place. So when OSHA comes out and they're asking for the program, things that they're going to want to know: how do you measure temperature? Do you use if you use the app, I think that's fine. If you have people that know how to use the wet bulbs, globe temperature readings, that's even better. How do you track it? How do you communicate? So you're measuring it, but how do you get that information out to the field so people know what to do? They're going to ask about the water. I talked earlier, like, do you have an unlimited cool water supply? Is it accessible, right? So there's a difference if somebody's working in a boot pit or somewhere, and the nearest water is a quarter mile away. That's a big difference than having water set up where it's accessible. So if somebody feels the need to take a break, that they can just go get that water quickly. Are you requiring additional breaks, particularly when there are high heat days, or are you at least scheduling breaks? Like I said, that the bakery employer that had a good outcome of their heat inspection, it was the fact that they scheduled additional breaks and built them into the schedule was one of the things that OSHA really seemed to appreciate in that inspection. Is there access to shade, right? If there isn't natural shade or structural shade, can you set up a tent or just put something out there to give people some shade? Again, I talked about acclimatization or getting people accustomed to it. Do you have that built into your program? Does somebody know? Is there a communication? Let's say a temp worker shows up. Is there a handoff? Is the supervisor or the superintendent made aware? Hey, we just hired this guy. He needs to be acclimatized, as opposed to, as I've seen in some unfortunate cases of mine, where someone just shows up. And I can remember the first job I had, or working with a contractor. It's like, you just show up and just put you to work, right? If that's what's going on and there's no kind of handoff where there's a communication of who this person is and what their background is, so to acclimatize them, that's going to be problematic. Do you have a buddy system in place? And then, are there other, I know in this industry, right, sometimes you will start early and finish early. That if you can show that you have administrative controls like that, we rotate people. We make sure that people are only working out in the sun for this amount of time. Obviously, it's not always possible, right? Certainly not likely that you're going to be doing all of these things all the time. But again, these are all parts of a program, I think, which when taken together are much more likely to result in a positive outcome. And then I think the last one is, again, the training. That's the other piece. So having that program and doing the training, and whether it's in-person training. I know Joe's got some really good online training pieces. That's a great way to get in front of your people, short modules that they can use and stay up to date. Some of my more sophisticated clients kind of do that quarterly training because they know people don't retain knowledge for terribly long. And so oftentimes training somebody once a year, it may not be enough for them to remember that. Want to do that training, certainly if it's heat related in the spring, right, as the weather is warming up, to make sure it's top of mind for people. So if you are inspected, what's the likely, if you get cited, what can you expect? As I said, odds are you might get a hazard alert letter, but if you get cited, it's again likely going to be under the general duty clause. They may also issue citations for PPE, for sanitation, which relates to not having drinkable or potable water. It could be for the accessibility to medical or first aid. Could also be record keeping. The one thing I think that has really caught my attention when I was reading the NEP, and I don't know if you saw this too, Jess, it was that the emphasis is going to be on issuing citations quickly and getting a commitment to correct or abate the hazard through settlement. What that tells me is that they're going to be issuing more citations or they will be inclined to issue citations even when they know that they may not prevail if the employer litigates them. And the reason why that's significant is it's expensive to litigate, so they figure, well, let's cite and then get a settlement that has abatement.
And I've also been hearing, and you've probably heard the same thing too, is this is justification for the standard, right? By doing this, by putting the NEP in place and the data that they'll be getting from the citations or having more citations, they can use that as a further justification to develop the rules sooner rather than later. Is that?
Yeah, I think that's absolutely right. And so if you get a citation and sometimes it will come with that letter like, oh, you can settle through the mail. Just we'll give you a 30% penalty reduction and you don't have to do anything. It's real quick and easy. I would encourage you, if you are willing to do some good things in abatement, OSHA loves, again, hiring third parties because they know the third party safety expert are going to be knowledgeable in the area, as opposed to, I'm going to have my cousin Sam do it, right? That's the sort of thing they like. So we've had good luck or good outcomes in representing clients and in settlement conferences where we agree to training, we agree to development of a program, and maybe a few other enhancements that OSHA can't compel through litigation, in exchange for the citation being withdrawn. We just got a record-keeping citation withdrawn last week where they had the employer dead to rights. There was no defense. Their logs were clearly deficient, but we agreed to retrain across the company everybody who was responsible for record-keeping and do it once this year and once next year. And so they withdrew the citation. So I think if we know that they're likely issuing more citations than are probably going to survive challenge, they might be more willing to delete those citations if you agree to certain commitments. Now that's not to say again, bad facts, bad law, if you had a fatality and you don't have a program and your supervisor was kind of indifferent to the person's situation as they were getting sick, they're not going to delete that citation. But I think there are good arguments or good ways to approach if you do get one of these citations that are issued very quickly to not necessarily accept it but still have a good outcome. I think we can kind of how are we doing on time? Do we have any, if we have any questions, we can take those. Otherwise, I did add at the end kind of what to do when OSHA arrives. And this applies not just to heat inspections, just kind of, I find, I was talking to John Lee earlier this morning, I find that the most mistakes are made when OSHA first shows up. So I'm happy to talk a little bit about that, but if there are any questions, yes.
For the emphasis program?
So it generally involves kind of letting the person kind of build up, right? Like signing them to lighter work, to less exposure to the heat. So if most.
Are you talking about employees that you know have the heat issue?
No, it's really primarily. I mean, I think there are two aspects when I think of acclimatization. One is for a new employee, right? Particularly someone who hasn't worked in let's say this person's last job was in an air-conditioned warehouse, right? And now they're doing grain handling work, primarily outdoors, doing heavier work. It's getting them used to the physical aspects as well as just the weather aspects. And then the other part, I think, is just seasonally. So, your employees it's been cold all spring, and then suddenly the first heat wave comes up. I think generally the idea is that everyone is going to need some acclimatization. But I think a lot of it, to me, the bigger focus is on people who are, if it's late July, it's August, maybe you get a new employee. To me, that's the real acclimatization, is looking at those people. So everyone else has been working at your facility the whole spring and summer. They're acclimatized, but it's making sure that your managers, your supervisors know, hey, this person's new, they haven't done work like this. And through the interview process, if you determine he worked at another grain handling site and he's just changing jobs, or he moved to Nebraska from Iowa, I don't think you have to really worry about it, but it's really knowing what they did before they came to you and building in that time for them to get accustomed to it. Yes?
So kind of along those same lines, have you come across any mention of like a significant aggravation of a pre-existing heat-related illness of any kind?
I haven't really seen necessarily aggravation of a prior heat illness, but just those underlying conditions, like the case involving the roofing company. And one of the real challenges for employers, and I don't think OSHA's addressed this, or at least I'm not sure how they're addressing this, is on the other hand, you've got issues with respect to the employment laws, like the ADA, where you're limited in what you can ask people, right? You're not supposed to make inquiries into people's health history unless there's a reason to do so. Now, I think there may be ways, right, given this issue, to say, like, you can ask the person, can you safely perform this type of work? You're allowed to ask questions like that. It's the same thing. You can ask them, are you able to perform the essential functions of this job? Can you lift this? Can you walk this far? Can you, bend, stoop, kneel, et cetera? So I think you can ask that question. And I've seen some folks talk like, well, can we go through a list of conditions? Can we ask them? I think that would be very risky. So I think you're better off asking, are there any reasons why you can't work outside, in high temperatures for extended periods of time?
Okay, so with that being said, we do like a pre-employment health screening with a pretty extensive voluntary questionnaire. So if they elect to say they've had a heat-related illness in the past, is there any rhyme or reason as to an accommodation for somebody that may state that they have had a prior heat-related illness? Or could that get you in some hot water?
I mean, I think I would probably ask, I'd be inclined to ask, was that prior heat illness, was that something, do you know why it happened? Do you know do you know if you're predisposed to that? Or I mean, I think once, if they disclose that, I think you're okay asking some questions, right? With the point being, look, if you got an EEOC complaint, I'd be very comfortable defending that, saying, look, this is an employer that has folks working in high heat situations. They're trying to comply with the OSHA requirements around heat. this person disclosed this condition, and so they were simply asking some questions. Like, I would avoid asking them, well, what is your underlying condition? Like, what, unless they volunteer it, kind of getting into, when you think about accommodation cases, it's not so much what the condition is, but I suppose what are the limitations. So if the person says, like, no, I'm fine, that was just, I forgot to drink water that day, right? But if they then say, well, I have this underlying condition, I think then that I would work with your HR team or your lawyer to make sure you're then, because then you're treading into, I'd say, somewhat dangerous ground, and we want to make sure the questions that you're asking them are appropriate, but you can begin that dialogue, certainly. Any other questions?
So you stated that when we get at that high heat index, there's other steps that we need to do? I'm from Texas, we're in high heat all the time. So
Yeah.
what are those additional steps that you would recommend?
Yeah, I went to law school in Austin, so I spent a few summers down there. Yeah, I used to be able to play basketball at 2 in the afternoon in the sun when I was 23, right? And I think that kind of speaks to the different risk factors and where you find your employees. I mean, there aren't specific things. What I'm talking about that, it's really that at least in California there may be, like, I'd have to go back and look at the standard, whether it's like an additional break, whether it's more that you're checking in on people or things like that. Right now, there's no specific things that you need to do under OSHA. It's just kind of a lot of it is based on whether it's a heat warning, or a heat advisory, et cetera. That a lot of it's going to be with how much attention OSHA is going to be focusing on it. So I think basically, yeah, the hotter it is, the more they're going to be making sure that there are those protections in place. But I can look into that and get back to you if you want.
What about those that are parts of like a SHARPS program? Would that preclude them from being a part of the NEP?
I'm sorry.
Sorry.
Yeah.
What about those facilities or locations that are a part of the SHARPS program? Would that preclude them from the NEP?
I don't think so. You mean kind of like the VPP program, or yeah? I mean, I'd have to look. I know sometimes there are exclusions for folks that are part of the voluntary recognition programs, but I don't know specifically whether that exempts you. I would tend to think not, but it is possible. It's something, one of the things, and this kind of gets to what I was talking about, like what to do or starting to talk about when OSHA arrives, sit down for that opening conference, and that's your opportunity to ask that question of the compliance officer who's there to inspect you and say, hey, we're a member of this program, like, are we exempted from this? And like, odds are they're probably not going to know the answer, but you can easily access the NEP written program on OSHA's website, or if you really want to be proactive, have a copy of it in your office, and then go read the program, right? I think one of the biggest mistakes employers make when OSHA shows up is there's at least some clients, is this rush to accommodate the compliance officer. Like, I know a lot of them, they sit there and they're looking at their watch, they're huffing and puffing, and they're acting put upon because you're making them wait. But they are going to wait, right? If you insist that we run this issue down before the inspection begins, they'll run it down, and they'll either pull the NEP themselves or they'll call back to their office. It's your opportunity. If you have counsel, give your lawyer a call, give your safety consultant a call, and they can run that down for you. I've had quite a few inspections where even if I'm not present with the client, they call me up. I get on the phone with the compliance officer and I say, hey, look, we need to run this issue down. We need to figure this out. We don't think that our client is covered by this emphasis program. So whether it's because you're a member of SHARP, whether it's a NAICS code issue, it's not uncommon for OSHA to show up at the wrong site, right? Or they've got your NAICS code wrong. Could be because you've got the NAICS, someone in your establishment put the wrong NAICS code in when submitting something to the online data submission, and you can pull out some records and show them you're actually in a different NAICS code, then they should leave. So it's taking the time to get that right and run that issue down is, I think, a good investment of time. All right. Yeah, I think just I'll just run through this because I think it's important information. So my goals when I'm managing an inspection with a client, and whether, again, some clients call me at least in or around, within an hour and a half or so of Chicago, I'll drive out there. Sometimes I'll jump on the opening conference by telephone while I'm driving there so I can be present for the actual walk around. But we're trying to control the flow of information, right? It doesn't mean we're not giving them information, but we're giving them the information that we're required to give them. We're managing the interviews, right? So we're making sure that supervisors, superintendents are prepared for their interviews. I rarely make managers available that first day because I need to take that time to prepare and get them ready. Want to minimize the disruption to the business. The OSHA Act says that the word reasonable appears in the section about inspections about 4 or 5 times. That inspection must be done in a reasonable manner, a reasonable time and place, in a way so as not to disrupt your business. The compliance officers aren't going to tell you that, but you do have those rights as an employer. So if a compliance officer says, well, I want to observe a bin entry. Well, if you don't have one scheduled that day, you don't have to do one, right? You don't have to shut down something so they can see it or turn on a line or do something like that. Obviously, we want to cast the workplace in the best light, and there are ways that we do that during inspections, and part of that, again, is making sure people are prepared for their interviews. I prepare managers, I prepare hourly employees. I do hourly employees differently, right, because there's no attorney-client privilege with them, but I get them ready by making sure they know their rights, so the compliance officer doesn't kind of intimidate them. Maybe they want to end their interview early. They have a right to do that. I go over the training that they've received so they're prepared to talk about it, because employees tend to forget about training that they've gotten. So I remind them of that. We go over the documents. And then identify and fix potential problems early. Fixing something during an inspection doesn't mean you're going to get cited. If they find something wrong, they're probably going to cite it anyway. So you want to get the credit for fixing it without admitting that it was a hazard, right? I have seen that happen, but fixing it early. Let me just talk about, one piece I want to emphasize, and this is all, you can assume the deck is available. So, and if anyone ever has a question, again, I'm always happy to talk. I'm not one of those lawyers that just bills for any time anyone calls me, so feel free to shoot me an email or give me a call. The important things for employers to remember in inspection, like I said, you have a right to a reasonable inspection at reasonable times. You have a right to demand a warrant. It's not something I typically recommend in certain circumstances, particularly I think if OSHA has been harassing your company or taking an approach and I don't say that lightly, or I think it happens very, very rarely, but I generally don't find it to be productive to insist on a warrant because they're likely going to get it. You have a right to an opening conference. I think that's one of the most important phases of an inspection, because that's where you talk about the scope of the inspection. It's where you discuss what's going to happen, where they're going to go, who they're going to talk to, talk about how the interviews are going to be done, right? Done a lot of COVID inspections with healthcare employers, and we talk about before the compliance officer goes out on the hospital floor that we really can't accommodate interviews because they're actually, the people on the floor are caring for patients, and they generally will agree to that, right? We'll figure out another way to do interviews. So, if you only have one person or 2 people working at a site, and pulling that person away from what they're doing is going to disrupt your operations, you talk about that with the compliance officer and try to figure out a way that, like, we'll make this person available on their break, or we'll have them call you later, we'll schedule it up for tomorrow. A lot of times they'll be flexible, particularly if you approach it in a way that we're cooperating, we're trying to get you the information that you need, but we need to do it in a way that doesn't interfere with our business. You have a right, if you have trade secrets, to protect those, both in photographs or videos, as well as documents. You have a right to accompany the compliance officer at all times, except when they're doing private interviews of non-supervisory employees. You not only have a right to participate in all management interviews, but that's the one area where if you are thinking about having a third party or lawyer or consultant is in that management interview, someone to support that manager, to make sure that the compliance officer is asking appropriate questions and not kind of overstepping. Then you have a right to a closing conference and to challenge the citations, obviously. But to me, like, again, the one thing I really just wanted to talk about is that it's that opening conference. I've seen most of the mistakes or things that send the inspection in the wrong direction or end up in a bad way is that opening conference and that effort or desire to kind of get this done quickly. You bring as many people, you bring the GM, the superintendent, the supervisor, the safety man. So I've walked into opening conferences where there are 7, 8 witnesses or managers all in that meeting. And then the compliance officer is just asking all these questions and writing all this information down. And there's a rush, let's get out there, let's get this done. But so I find that slowing down, making sure you have the right people in there and not anybody unnecessary, making sure the people that are in there have prepared for this so they know what to do. They have routes, how to get to a certain area with limiting kind of where OSHA goes. So it's really just kind of I would say take a breath, figure this out. Don't be afraid to make the compliance officer wait while you figure these things out, and then go in. Again, call if you're working with a consultant, you're working with a lawyer, call them, kind of talk it through, and then begin the opening conference. They will typically wait anywhere from 45 minutes to an hour and a half, because and provided particularly that you're saying, look, we're gonna give you access, we're gonna cooperate, but we just need to get the right person here. We need to talk to somebody. Their option at that point is to go drive back to the office and get a warrant. But if you tell them we're going to give you access, we just need to get everything lined up and get the right people here, that's not a basis to get a warrant. So just take your time and make sure you're ready, and then start the inspection. So I think we're right at 11:30.
Are there any other? Oh.
So when the investigator comes and requests a conference with one of our employees, and the employee does not want to do that privately, he wants to have one of us in there with him, and the investigator says, no, it's got to be privately, is that allowable?
It's, that's a common question, right? I will tell you, I've never had a compliance officer that has agreed to let me sit in on an interview. That's in their mind. I think I skipped over one of the slides, like OSHA's inspection rights, right? So they have the right to inspect records, to collect evidence, and the right to conduct private interviews. They interpret that privacy as their right. My view is that the privacy right is the employee's right. If the employee wishes to exercise their right to privacy and say, I don't want my manager in here, right? Because I'm going to say something that I don't want them to hear, maybe, or I just don't want them to know what I'm saying. It's the employee's right, and I take the position the employee can waive that right, or can say. So, I'm sure most of you probably are not unionized workplaces, but absolutely, if there's a union present, and I will tell employees when I'm preparing the hourly employees, look, if you want your union rep here, you can absolutely insist on it. And OSHA will have to go along with that because it's your right to have that person there. You have to be careful, right, when you're preparing or you're talking to that employee. If you say to them, you have a right to have me in here, or your supervisor, that could be perceived as kind of telling the employee that you want them to ask for that. So I always kind of present it like, look, you have the right to have someone in there or not. You have the right to. And more so what I do is I say, look, you also have the right not to be interviewed. You have the right to end the interview at any point. You have the right to take a break. And I really focus on the rights of the employee as well, so they understand that they can exercise those rights. And if they say to the compliance officer, I want my supervisor in here, I want my manager in here, and OSHA says no, then I tell the employee, well, then you can just decline to be interviewed. So that's again, you have to be careful how you say it, but that's the way I approach that. I mean, sometimes sometimes OSHA they may then threaten that employee, like we're going to get a subpoena, or we're going to compel you to sit for an interview. I mean, if they do that, they do that. I don't think the employee is going to be terribly cooperative at that point. So I am careful about trying to insist. I think I probably only sat in an employee interview once, and that was after a lot of back and forth.
Well, I have a question. Crystal ball, you know, for the next couple of years in the, you know, with the Biden administration and Assistant Secretary Parker, what do you see as the priorities? Obviously, this NEP that you've talked about, that's kind of the big issue coming up. The rulemaking that we know about with the heat injury and illness standard, and also the priority for the Secretary of Labor is that they want to hire more compliance, safety, and health officers. So what do you see coming within the next 2 years within the agency and their priorities?
Yeah, I think the other big one is going to be workplace violence, probably limited to healthcare, maybe certain retail sectors, but I think it's really healthcare and emergency rooms and particularly mental health facilities. So not a priority. I think that will affect this industry in any way. I think the other thing is just that, again, that really increased focus on enforcement, the continued use of press releases, and in some interesting ways, some of you all may have heard the concept of regulation by shaming, so that the agency knows that for many employers, even a $150,000 fine may not be a big deal, but negative press is. And so we see lots of press releases being issued when the citation is a certain dollar value, or it's a particularly interesting or unique set of facts. What I saw recently in one press release, which I hadn't seen before, is that it specifically identified the name of the safety director who had committed to fixing this problem in a prior settlement conference. So I think kind of they're always looking for new ways to use that shaming ability. Now, whether it's calling out a specific person, I think under the Obama-Biden administration, David Michaels went to Asia to meet with the heads of car companies in Asia because they were having so many problems with downstream suppliers in the United States that were unsafe, that they were trying to use the cultural focus on safety in Asia to shame those employers. So I think we're going to see more of that. And as I said at the beginning, I think it's just going to be a lot more getting out there and doing inspections again, because they've, many area offices really didn't do inspections for a year and a half.
Yeah, and I think getting back to that with the press releases, I know that's something we dealt with in particular with some states in particular, and that's where the press release would come out even before the company found out that they had gotten a citation. So they'd be reading about it in the news or something to that effect, and it was like, well, wait, this is news to us before, those were some of the cases that we heard about.
Yeah, we had a client that learned about a $260,000 failure to abate citation because it was sent to collections, and inside OSHA, Bruce Ralston called the employer to say, what's your comment about this? And they didn't even know about it. So.
Well, good. Are there any other questions, comments for Aaron? Okay, well, I know he'll be sticking around for a little bit if anyone wants to have any sidebar conversation. Thank you very much.
Thanks, everyone.
All right, is it on? There we go. All right, so please join me in thanking all of our speakers for their presentations during Convey 22. So we've come to the end of the Convey 22, the conference presented by NGFA, Jeeps, and Granger. We appreciate your attendance and participation. Once again, we'd like to thank all of our exhibitors and generous sponsors for helping to make this event possible. Our partner sponsor is CCS Group. Our supporting sponsors are JD High School and Company, McPherson Concrete Storage Systems, Safety Made Simple, Schooler, and West Side Salvage. Our contributing sponsors are CoBank, Macon Construction, Sukup Trinity Trail, and United Grain Corporation. Speaker PowerPoint presentations and videos of the presentations will be available by the end of the month, which is about 2 days, at convey22.com. Also, as far as here are the dates for the upcoming Jeeps Exchange starting in February 2023 in Kansas City. This year's Harvest Safety Week will be held August 22nd through the 26th, and you can go to the NGFA webpage. There I have some of the flyers too for more information, and Aaron will be doing a very similar presentation. So if you have any of those within your company that you would like to view and see it on the NEP, that would be great. And don't forget about NGFA's 51st Annual Country Elevator Conference, which will be held December 6th through 8th in St. Louis. We would appreciate if you would complete the conference evaluation form that we will email to you tomorrow to help us prepare for next year's Convey 23. The date and venue will be announced this fall. Once again, the NGFA, Grain Elevator and Processing Society, and Grain Journal, thank you again for attending Convey 22. And also, just to let members, the NGFA, our Safety, Health, Environmental Quality Committee, will be meeting immediately after this conclusion. It's in the Paxton Room. So all you have to do is just go out here and make a right, and the lunch out there is only for the committee members, all right? So I don't want to see anybody else. I'm going to have to be the lunch police out there, so I just want to let everybody know that. So anyway, once again, thanks for coming, and look forward to seeing you at next year's Convey. Thank you.